Good morning, everyone. It is a great pleasure to take part in this 10th Congress on International Tax Law promoted by IBDT, particularly together with professionals of a high level and the panelists of the second day of this event. We'll be talking about international tax planning. In this panel, we will discuss topics that are very provocative and also key for everyone who work with international tax law. We'll examine national rules that apply to taxation of associated and other companies and also their relationship with international treaties within the Brazilian legal system. We also going to discuss the rules related to a capital gain for non-residents with regard to the selling of assets or national assets. And lastly, we'll also speak about the issues related to amortization of premium by foreign companies when they have operations involving other companies. And also, we're going to hear Professor Maisto with a talk who is going to give us his overview as an European expert on all this topic of international tax planning. So as you can see, all the topics are very relevant. And this is what we're going to have at this first panel. And this is why I would like to pass the floor to Leonardo, the moderator. I'm sure that we're going to have a very productive morning. Good morning, everyone. It is a pleasure to be here in this panel. So to start the panel of the day two, I would like to pass the floor to Alessandra Okuma. She will speak about the interaction of the CFC rules and the treaties in order to avoid double taxation, especially to see the Brazilian laws and if they can be considered CFC rules. So you have the floor, Professor Alessandra.
Bom dia a todos. Primeiro eu tenho que confessar para vocês que eu
Well, I have to confess that I'm nervous to be here because this is such a grander room with a wonderful crowd here. Yesterday, I was talking to one of the organizers of this Congress, and I heard that the first edition of this Congress had 73 assistants, and today we have 502. So this means that this is a great success, and this has been built over the years by IBDT every year. So I want to congratulate all the organizers, Marto, Luis Organo, Luis Flavio Neto, for making this happen. This is a great event which is of highest importance here in Brazil on international tax law. Congratulate also all the planners for having putting up panels with equality of gender, which is difficult to see, especially in these topics. And as being this an international congress, this is even more an achievement. I am one of one of the people have fought to open more room for women in this field, and I can see that this is very well occupied by bright women. So I'm very happy to see this. Then I want to thank Mara, Caramico, and Fabiana, my friends, because they are the greatest women IBDT who have opened the doors to myself and many other women. So I'm really proud to be here. And as a soccer player who usually goes to a big team, I really feel that this is a big responsibility. So I try to stick to my time, and this is a topic that I have a passion for. So my challenge here, and this is what I learned with Leonardo Leão, Marta Leão, and Leonardo Aguirre is trying to answer a couple of questions. So first, I'm going to speak about the law 12972 to see whether this is really a CFC rule. So if so, then the next question to answer is to see whether it really complies with all the DTTs in force, and then if there is any conflict, what should prevail? So first, I'll try just to make like general comments the on controlled companies and associated companies. Then we're going to go through all the treaties in force here in Brazil. And then also just going to give you an overview of the OECD guidelines for designing the effective CFC rules and the BEPS. And lastly, I will end by speaking about administrative and judicial court decisions. Well, this topic is very controversial, and I have been studying it since 2001 when the provisional measurement 2021 or 2158 was passed. And this has the assumption of distribution of earnings of associated companies or controlled companies based on the accrual basis. So, this was very questionable, and there was also a declaratory action at that time. And in this action that was challenging the Constitution, the Supreme Court of Brazil decided or ruled that it is unconstitutional to have this automatic regime of distribution of earnings by associated companies that are not in tax havens. On the other hand, it is constitutional for controlled companies that are in tax havens. So these are the two different opinions that prevailed. There were many, or there was a lot of discussion on this, like the application of treaties, but the decision was not unanimous with regard to this. So this is why the Supreme Court was divided in terms of this. So unconstitutional for associated companies in non-resident in tax havens, and constitutional for controlled companies in tax havens. And then the decision of this is precisely this. So, the anti-elusive of this law, character of this law. So, the concepts of control and the fact that the control companies can be incorporated in tax havens and also to be used in order to distribute the earnings to be taxed here in Brazil. So this was the basic guidance adopted by the Supreme Court to rule about or under the law 12973. The regime was considered unconstitutional according to the MP, and then we have this law 12973, and then establishes this establishment for control and associated companies, and it has to do on the results of the controlled companies that will have to be on a pro rata basis of the controlled company. And now, abiding by the decision of the Supreme Court, then they have that there's automatic distribution for controlled companies that are located in tax havens and for other controlled companies. But in the case of associated companies, distribution of profits would take place only when there are legal events that will show that there is availability of income, legally speaking, which means credit, payment, remittance, those ones that are already known and that are under the previous law, or this law, sorry. And then today we have this law 12973, which is the law that deals with the distribution of earnings of companies located abroad. And there is also indirect taxation. And I have a doubt about the recognition of these earnings in Brazil because of indirect profits earning abroad of companies that are not resident here in Brazil, this is really something questionable. And this is why I would like to hear Dr. Maí's opinion on this. And this is the law that has been enforced, and also for countries with which Brazil has a treaty about double taxation. So this law 12973, in my opinion, and also the opinion of Professor Roberto Xavier, was also the opinion of Dr. Schrader and also Ramon Tomasella and Bianco. So this law clashes with Article 7 of the DTT and also with Article 10, because Article says establish that the profits of an enterprise have to be taxable in the country of residence of the country of the company. So we have a different kind of association here. So according to the principle of personality and also the principle of availability of income and also allocation of profits of companies established in different countries. So this is how Article 7 is enforceable. And Article 10 confirms all of this. So when speaking of the distribution of profits in paragraph 5, it is very clear that the distribution or dividends that have to be taxable are the ones that are effectively paid. Without this legal availability and economic availability, there is no way for you to tax the profits of these controlled and associated companies, except for the other rule that can be enforced and that deals with treaty shopping. Yesterday, you heard the talk delivered by Ramon. He spoke about aspects of the new Brazilian policies and how Brazil has been negotiating the treaties to avoid double taxation. And one of the aspects he addressed was precisely the change of position of the OECD. In 2003, OECD included in its comments the possibility that the treaties, in order to avoid double taxation, would also include the CFC rules, and this is included in Article 14. So this means that this is set forth in the comments of OECD. Brazil also included this in some of the treaties that it signed. So these are the comments, for example, paragraph 14 and 81, which deal specifically with this topic. So it makes clear that the treaties cannot be enforced in order to ignore other CFC laws. Exception is given according to the OECD comments, extended version. Luxembourg and Belgium showed that they expressed comments saying that they consider that the application of control foreign company legislation contrary to the provision of paragraph 1 of Article 7. So we have to consider this when we have any treaty signed with Belgium and Luxembourg, because this is their position with regard to this topic. And today, in the most recent treaties that Brazil signed, Brazil changed its policy in signing treaties. They include a rule that says that the text of the treaty is meant to avoid the deferral payment of the income tax, such as the Control Foreign Corporations CFC's legislation. So our interpretation here is to understand first that Brazil is not part of the OECD, so its comments are just soft law. So these comments that are soft law may be applicable in a dynamic way in order to change or amend the treatments that were signed prior to 2003. prior to this new version of the commentaries, there is a question that so far has not been answered. And I haven't seen this discussed consistently under the Brazilian legal system. So I don't know whether interpretation of the treaties has to be dynamic or static. I imagine that by taking into account that we have Article 31 of the Treaty of Vienna saying that the text is part of the interpretation of treaties, so I imagine that which context refers to that context of the time when the treaty was signed, but this is not something that is consolidated. So there is still a lot of controversy related to this. The fact is that the treaty signed by Brazil with um, Arabian Emirates, Mexico, Peru, Russia, Singapore, Turkey, Uruguay, Venezuela, and the UK includes this paragraph. So there is this remark saying that the interpretation of the treaty cannot cannot ignore the CFC rules that enforced within those states. Then we move on to the other part. So is law 12973 effectively a CFC? Because BEPS Action 3 establishes that for you to have a good legislation, you have blocks, which they call building blocks. So I'm going to highlight three of them that are the most relevant ones in my opinion. I think that these three are very important to be considered because you should have a definition on the control and significant influence for you to establish the scope of the CFC rules. It should be personal too. And the CFC rules must be enforced when you have the control company, resident company, which establishes a taxation regime that implies less burden taxable than the country of residence of the company. So there is another restriction establishing that the CFC rules have to have a spatial delimitation or border established. And the other one is related to the revenue. So Action 3 of BEPS recommends that the CFC rules should apply when there is the company has profits or other has income resulting from royalties, interests, or any other means like that. And Law 12973 did not include any of this building block perspective. So it applies to any control company or associated company, and many times, regardless of the resident company where the company was incorporated. And it also, or the Brazilian law also establishes that asset income should exceed 80%. So this means that the active income is unproportional to the character of this rule. So this means that Law 12973 is much more a technique for you to collect income or taxes rather than a legislation that is really a CFC rule standard. Law, I believe that because it has this broad scope and because it does not establish any difference that show an abusive situation, it doesn't have this character of being just an anti-elusive character. And because it is a legislation that is not precisely a CFC rule, it can also be applicable to treaties to avoid double taxation. Well, this is a question. The protocol of most recent treaties, for example, signed with Arabian Emirates, Mexico, Peru, Russia, Singapore, Turkey, Uruguay, Venezuela, and UK, the protocol makes it clear that the treaty will not avoid the enforcement of CFC rules and other similar legislations. So
So includes there, according to my point of view, also the 12973 by force of this provision from the protocol of these treaties. It would be in accordance with these treaties and it must be enforced for the specific cases. These exceptions confirm the previous rule that in the other cases regarding the other treaties, 12973, it's confronting Articles 7 and 10 of treaties to avoid double taxation. Well, with this controversy, especially regarding the light of the previous legislation of 2518, led many times to CARF. And by 020, we had mostly the jurisprudence that the tax transparency would not be pushed away for the by the double taxation treaties. By 2021, we had an amendment regarding the quality vote, and so in case of ties of the CARF upper chamber prevailed the position more favorable to the taxpayers. And here we had votes that fantastic, and my friend Liga, who is here with us, Jefferson, also fantastic by the non-enforcement of 2158 for those cases where it is treated to avoid double taxation, grounded Article 7, 10, and votes that were very well draft and they deserve being read. Then 2022, we have the vote of quality by the president of the group, and then again we have decisions against taxpayers which end by winning by majority in such scenarios. As for CARFI, it has the composition change from time to time and case law is prevailing, but the situation is not yet defined within the scope of CARF. It needs more. It needs to go deeper. And I saw some interesting votes, and even by a councillor of Guilherme from the USP of Ribeirão Preto, very good, which addresses precisely and brings the comments to OECD to explain the use of 2158, but this deserves more details in the theory side of this, because 12973, 2158, these are rules which are not precisely CFC legislation. Well, with this, it also was was referred to the judiciary, and we are saying that with a precedent of the Supreme Court saying that the 2158 could not be enforced for those situations where we have a treaty. This precedent was the subject matter of an ordinary appeal that will be assessed by the Supreme Court. We have in this case already a favorable vote towards the taxpayer by André Mendonça. The STF, or Supreme Court, traditionally had rulings equiparing international treaties and of the domestic rules and standards. In these cases, the chronological criteria was adopted by the Supreme Court. It will not be applied 90 end of CTM. The Gilmar Mendes for Volvo case, André, leads to topple this paradigm. Appointing towards the idea of Gilmar's vote for the mask theory, it provides the treaty is dealt as a rule that should be complied with by the domestic legislation. It quotes good faith, Vienna Treaty. There, it's all mentioned, and also it addressed the OECD comments, anti-evasion rules. So these both votes are well constructed, signaling towards a change of understanding of the STF Supreme Court's prevailing international treaties compared to domestic legislation. With this, my time is over. I said to Leonardo I would not not go beyond the time given, and I thank you for the opportunity. Thank you very much. Thank you, Professor. The CFC rules and interaction with treaties issue is not a polemic issue of today. So we see a vote of Minister André Mendonça. Perhaps the Supreme Court will see the compatibility of CSC rules and treaties. The second presentation of this panel, Doutora Maria Carolina Mendonça, will share with us a presentation regarding the acquisition of shares by foreign investors on a partnership and criteria enforced by CARF to recognize the possibility of amortization of this premium. So, Professor, you have the floor. Good morning. Obrigada, thank you, Leonardo. Thank you for the invitation. It's an honor to be here. My peers of this table, I congratulate you all. Today we share a subject. It's part of my daily affairs. Is acquisition of equity interest by a conduit company that happens when it's done by foreign investments. And conversely, for what Alessandra mentioned regarding foreign profits, is decided by the CARF quality vote, and the acquisition of equity interest by conduit company, especially for those cases this acquisition happens through a foreign investor, it's decided by the majority in many of the cases. And the idea is here to bring you what are these characteristics that make these cases be decided by majority and not quality votes, comparing the criteria defined by STG's decision that the so decided by the acquisition of equity by conduit company and the criteria adopted by the CARF. First, a brief introduction explaining briefly what it is the acquisition of equity interest with premium with conduit companies. And I'll talk about case law of STJ and jurisprudence of CARF in an overall regarding the acquisition of equity with interest with conduit companies. And following, to wrap up the subject of my theme, and the what happens when it's this acquisition of equity interest made by the foreign company. Initially, the acquisition of equity interest, it happens when a foreign investor pays in the capital in a vehicle company, and normally it's a holding. Many times this company is established in order to allow the amortization of the spread, and it's ephemeral, this amortization. And following, when these resources transfer to the holding through paying the capital or debt, the holding will acquire the equity interest, and with this record in the spread in its accounting, so it's booked. So we have the acquisition of the equity through between the holding and the invested company, and with this, the spread will be amortized by for tax purposes. What happens? The tax authority alleges that there was no equity confusion between the actual acquiring company and the invested, because the tax authority see the acquiring company as an investor abroad, which was that first negotiated this selling and first invested resources in the holding in order to acquire this acquisition of equity interest. So we have this acquisition of absence of equity confusion between the actual investor and the invested company. And the following accusation correctly, is regarding how artificial is this holding. Commonly, tax authorities requires a structure of this holding that in practice is not seen. In fact, this company established to make possible the amortization of spread as a vehicle in this operation. And to wrap up the cases of acquisition of equity with interest with a conduit company, it's important to recall the amendment that 12973 brought with this regulation of premiums. So until this law 12973, the spread could have a market value, future profitability, and a goodwill, intangible, or other economic reasons. And so the possibility of tax amortization was goodwill based on expectations of future profitability. After 12973, the spread would understand only the difference between the acquisition cost of the investment and the addition of equity acquired within the assets. But what could be amortized with this spread, the only spread is the one regarding the expectations of future profitabilities. Until 12973, there was no uh, express explanation on it. So after the law, the law is clear in this situation. And furthermore, before 12973, to evidence the booked values of the amortization, there was just a support documentation that would show what was booked. After 12973, we need an expert report record on the inland revenue or in the notary public. And the last point, the most important for me regarding the subject today, before 12973 and after it, absence of provisions regarding a vehicle company for the amortization of the spread. So this expresses one of the arguments adopted by the Supreme Court's judge last year. So there's not a prohibition or any legal hurdle to prevent or to establish a conduit company for making possible the spread task or fiscal amortization. So the Kramer case, it was analyzed the goodwill transaction between related parties, which is known the internal spread, or also the use of goodwill using a vehicle company. So this sentence by the STF a priori the rejection of vehicle company contradicts the law that governs the partnership company. So it's using benefiting from tax benefits. The legislation does not prohibit the use of conduit company to do the business. Furthermore, it competes to the excise to show any artificial resource used, the use of conduit company to be deemed as an abusive situation. So this was decided by the Supreme Court, and what we see today at CARFI, this is a subject that frequently undergoes to the first group of the Supreme Court. And according to the first group case law, we have to see three currents regarding the subject. The first view, it advocates absolute impossibility of tax amortization of goodwill using a vehicle company based in arguments used by the excise, or so absence of assets confusion between invested and actual company, and also the existence of this holding. So the second view, in opposite way, understands tax planning like as an actual attempt to look in saving in taxes would not be submit to the excise if there was analyzed actual existence of vehicle company utility for the business, because those who adopt the second view, up as of the moment, investors, foreign investors, pay in resources in a holding and vehicle company, these resources belong to this holding, and when the latter acquired equity of the company, equity of the that holding was transferred through capitalization or debt. But what happens currently in the practice, the subject is defined but the second current. So this is the second current that will or view does the casuist analysis and sets forth if the case will be judged in a favorable way to taxpayers or not. And what the second view says, it analyzes the acquisition of the vehicle company and its use for the business. And here, this talking about acquisition of equity interest by foreign investors and in a transaction within the country. When we are talking about an acquisition with foreign investors, we have some peculiarities that were stressed by the Supreme Court and also in make a difference during CARF's judgment. For CARF, they keep on finding based on the same arguments, absence and between the confusion of assets between the actual and invested and artificiality of the conduit company. An additional argument is used in the sense with it was only established a hold in Brazil because this would be the only way to to do the amortization of spread for tax purposes. And for the Supreme Court, establishing a conduit company for foreign investors is justified furthermore either to make possible for the amortization or due to operational issues so the business can be conducted in local currency to make easier the acquisition of equity. And as for CARF, the first group, the analysis remains case by case. First view and third views adopt the same arguments that I just mentioned, and the second view poses some peculiarities that matter towards a favorable judgment towards taxpayers. And I brought you three cases, all from this year. The two first ones favorable to taxpayers, and the third one the opposite. And those who are favorable to the second view made a difference on the sentence. So I'll show you the important aspects that made difference that led to the favorable sentence to taxpayers by majority. So the Supreme Court ruling 9101006940, a second view, in the case there was no the absence of claims or non-existence of fact or simulated existence in spite of the short duration of the company. In this case, conduit company had accounting records, both financial income and banking tax and expenses were paid by own resources. So this was an important point that mattered to the sentence and those related for the second view. And finally, recurrent point, in this case, foreign investors, they had a structure in Brazil and they had operational companies in the country that could acquire the acquisition of equity and opt to do through holding to spread to divide the business and make easy to operate. So the judge understood that an investor could do this operation or transaction differently, but it chose to do it through conduit company and the result would be the same. So the transaction would be neutral tax wise. In this second STF decision 9101007053 ruling by the STF, there was a short duration of the conduit company with temporary nature. There was an accusation of fraud or simulation that was detached throughout the administrative process. And finally, a point that made a difference for those who judges who followed the second view was the fact that the foreign investor had a structure in Brazil and the possibility of acquiring the equity. There was established here an operational company here, but did towards the conduit company the holding. So the outcome reached would be the same, either by the conduit company or the company operating here. And to final wrap up another case, which is controversial case 9101-066-0807. This was the third view. For those who followed the second view, all negotiations to invest acquisition were conducted by the foreign investor. Foreign groups that engaged and funded the expert report for the acquisition of the investment in Brazil. Resources from abroad remained for less than 1 day in the conduit company, so they came to the holding and then were transferred to the transferring entity for based in contract. The conduit company was just formalized when they signed the contract, and there were no points operation regulatory that could justify the establishment of the conduit company. And an exception, which is quite interesting.
Is especially of the adopters of this second current line, is that an acquisition of interest in a company for a foreign investor, when there are many foreign investors at stake, is very common that the vehicle company constitution tries to facilitate acquisition of that investment. So this would just be justified, but in this concrete case, foreign companies just got together as a consortium, and and the company was acquired by this consortium. So this justification would not apply to this case. So, as a conclusion, what we can see is that based on examination of the Supreme Court decision, they corroborate the decision that this depends on the peculiarities of each case, so that the use of the eco company can be or not admitted. However, in the cases of equity interest acquisition by foreign investors, the Supreme Court seems to be less strict than the CARF counselors. Because for the STJ, or just because the resources come from abroad, this would justify establishment of this vehicle company. And for the CARF counselors who define the result of this decision, understand that an analysis should be made about the existence of this vehicle company and its usefulness in this business. So the examination will be much stricter than the one used by the SDJ. So this is what I had to tell you. I would like to thank you again for your attention.
Carolina.
Thank you, Maria Carolina. So as optimization of Premier Carve is always controversial, so it also generates a lot of discussion. So we have the QR code that is in the screen, and this is for you to make your questions. So we're going to try all these topics in the end of the day. So if you have any question, just try to scan that QR code for the last panel. Now let's move on to the third talk of this panel, Professor Ana Carolina Mongilo. She will speak about the taxation of a big capital in indirect alienation, which has been showing different experiences, especially because of the changes of domestic ruling. So she's going to give you an overview on how this can be played and some of the main cases analyzed by CARF. Thank you, Leonardo. First of all, I just like to excuse myself from to speak from here because with age it's very difficult for you to see things from afar, and I will not be able to see my slides from the tribune. So I'd like to start by congratulating IBDT for this wonderful congress. This is a beautiful room with a big crowd. Thank you very much for the invitation, Professor Schrader, Luis Flavio, Rodrigo. And also I would like to greet all the members of this panel. I feel very honored to be here next to Professor Maisto. I really admire you. And also next to Gustavo, Leonardo, Maria Ana Carolina, and my colleagues to discuss a topic that is fascinating, which is tax planning within the international scene. And then we're going to address something that is not really a piece of cake and is nothing just typical of Brazil. So I think that across the world, we have seen very relevant discussions with regard to taxation of indirect assets. In order to establish the boundaries of this discussion, I'd like to start by speaking of the topic that I'm not going to address. I'm not going to speak about direct transfer, but rather indirect transfer. But for us to understand how difficult this is, so we have to understand how taxation works in terms of direct transfer. So these are two situations. So in this case, we have an asset in Brazil that is being transferred by a non-resident company, and the purchaser is located abroad. The second situation is where the asset to be transferred in Brazil, so the to a foreign investor is brought or is bought by a company in Brazil. So there is taxation on the capital gain received by the non-resident in Brazil. So this is our foreign seller. But in principle, Professor Maestro, we should have a connecting element for this operation, like the Brazilian territory. We usually say that we should have something that would justify that the legal system applies to this in order to tax this operation. And now, speaking of direct transfer, well, I'm not going to elaborate this, but just to give you an overview. So this is the situation. This is the history of this case. So the rule is very important, dated 1995, that establishes that taxation of capital gains of non-resident companies has to happen the same way as the resident company is taxed. So it works the same way for resident and non-residents. And then tax is also on the income tax that is here in Brazil. In 2003, oh sorry, 23, through an MP that was converted in 10833, which is actually the law that establishes the non-cumulative COFINS. So this is like what we call as a turtle, so to speak. Here in Brazil, when we say that there is a law that deals with a certain topic and someone includes an article right there in the middle, doesn't make any sense at all with regard to the rest of the rule, we call that as a turtle. Because this is something weird. It's a foreign element there. And Article 26 was included in Law 10833 that deals with the non-cumulative COFINS in order to tax the foreign purchaser of an asset located in Brazil in order to give to the attorney-in-law of this purchasing the income tax or collecting the income tax on capital gains referred to the non-resident that is selling this asset in Brazil. I recall that I was there, and when this article was passed, it did cause a pandemic because it is foreign element, it is weird. It did not deal with tax in a direct way. It just attributes responsibility to the representative or the purchaser in this case. And also, at that time, there were other interesting articles that were discussed, very interesting about this law 10833. I recall another article published by Professor Gert about this topic. And this article was very discussed and questioned at the time. In my understanding, I believe that this article should be questioned depending on who this representative is, and also a question in light of the CTN rule, because as we know, a tax responsibility can only be attributed to a third party that is non-payer under a law, and this third party must have some connection with the source element of this tax. Because in this case, there is no control on the payment. The money does not go through them. So how can they be made responsible for this tax to be paid by the seller. So how the representative of the purchaser who is located abroad can be taken responsible for this tax? But this article has been enforced for over 20 years, and we do not discuss Article 26 of Law 10833 and during this talk, but what we our focus is to discuss what I say as the indirect sale. So indirect transfer. In this case, I think that I got lost with my slides. This is here. So this is the object of this discussion here. So indirect sale. So sale of shareholder abroad in a company with direct participation in assets located in Brazil. So in this case, abroad, we have a seller and they have interest in a company abroad, and in turn that has interest in the Brazilian company that is indirectly sold to a foreign buyer. Now when we look at this operation, we can see that what we have there, there is no connecting element with Brazil. Right, actually in this operation, there is no connecting element to see that this has to do with Brazil, and this operation it takes place totally abroad, and there is a change in the interest control that takes place abroad, or ownership is indirect. There's no connection with Brazil, so ownership takes place abroad, and then the premise that is accepted by many of you here is that Brazil has no GAR, and all these transactions should be examined now. Should be this one here, which is indirect sale, and should be questioned based on devices of simulation, fraud, sham, and things alike. Now, let's briefly examine three cases. They are emblematic and they were judged by CARF. Here you have the QR code. So if you want to access the ruling of the higher court, so let's examine the cases of COSAM. It was judged back in 2015 by CARF, Mineração Tijuca in 2010, and CPFL in 2023. Well, Professor Maisto, I'm just going to give you the conclusion of this discussion because unfortunately we cannot really give the details of it. But I believe that CARF does still has a judge at this kind of taxation cases. Even though I admire all the members of CARF, but some concepts have been somehow twisted in terms of its application. I think that we have to have a clear mind when we consider all of these cases. They have been judged over 14 years, and in that period of time, we cannot get from them a case law or a line of thinking or line of thought. Especially for those cases that were judged individually here, Professor Maisto, because any tribunal, whether administrative or judicial, plays a role to guide the taxpayer and also the society with regard to what the society can do with regard to that in the future according to the law. And when the ruling is erratic or something that is mischievous, is something that does misguide the audience or the society. Well, very briefly, let's see the cases. Time really flies. We cannot elaborate more on these cases, but let's start with this case of Mineração Tijuca dated 2010. On the left, you can see that this is a situation in which the asset negotiated is ruleless, which was held by individuals, and then after sale of Marules, so after several sales, individuals sold their interest in this company, which is Marolis, 1.5 million reals and 2 millions, and then later on it was negotiated for some dozens of millions as an indirect sale without any connection with the Brazilian territory. The conclusion of this and the conclusion of the curve is that there was a simulation, and curiously, the defendant does not really explain how the simulation would have occurred. So how had this money come to the individual's hands? Because they explained that there was a confusion. It's really a weird situation, something weird that happened here. But the IRS fined the purchasers, saying that there was a simulation because who was really selling that indirectly was individuals. But they don't explain what is the connection between these individuals abroad and individuals in Brazil. How the money went from one to the other. And the simulation was understood as being as taking place, but the operation was cancelled, meaning that taxpayer won the case, especially because of the passive subjection, because the purchaser was fine and the understanding was that the defendant should be the individuals. In this other case, in 2015, is the Cosan case, there was another simulation. So I'm not going to give you details, but what happens is that this case is maybe a little bit more complex because there was really a simulation. Because all the factual elements leads us to understand that from the very beginning it was known that the asset being negotiated was the Brazilian asset. And there was this transaction done abroad in order to facilitate selling this Brazilian asset. So in this case, I think that it was clear this effective occurrence of a simulation. So this is the Cosan case in a diagram. So these are the several steps. So Exxon was negotiated, or ESSO was negotiated by Dutch companies, and because here in Brazil purchased the Brazilian or the Dutch company. This is a cooperative that has the Brazilian asset. And I believe that here we have a more polemic case that would allow us to accept the simulation issue. This is a summary of the precedents, and we have to understand that there was foreign companies involved in here, and this is why simulation is the case here. This is the CPFL case of 2023, and this is what really bothers me more, and especially because the CARF experience should shed light on us, especially in terms of international tax planning. We should know what are the elements that should be considered, because in this case we had a structure that had been put up abroad many years ago. There was a holding company based in Spain that was owned by many non-resident investors, and I believe that this structure was set up in 2006, and the selling here occurred in 2011. And the IRS did not argument that this was a simulation. It just said that there was an abusive tax planning involved, yeah, and based on the fact that Jantos, which is the Spanish company, didn't have other assets, it was inoperative, and it was located in a company with which Brazil has a treaty signed. So it was a difficult situation, but this structure had been there for years, and on the interest of these foreign companies that you see on top. And for some reason, 2006 decided to have a joint interest in these Brazilian companies that were negotiated by using this Spanish holding company.
Therefore, heading towards the end, here we have arguments raised by the tax authorities and taxpayers in the case of CPFL. I just summarized briefly. And here the amendment case summary and the things that were, let's say, abusive tax planning, protected legal transaction, tax purpose, disregard possibility, direct sales, not accepting the indirect selling due to the what we saw, and also simulation, which is a structure that was possibly for the first decision was made by quality vote. The Professor Maestro, when we have a tie on the administrative court, at that time, the vote of the president in case in ties decided. So we had a decision by quality voting in a scenario that I think it was not a tax planning, abusive tax planning. Definitely was not. Now heading towards my conclusions, well, in 2021, we cannot forget we had a bill, very famous 2337. This bill tried to introduce in Brazil, Professor Maestro, a rule specifically trying to tax indirect sales. We have there a text that was sort of complicated, adopting some criteria, which we started to introduce this rule in Brazil. The Congress did not accept it and saying this taxation did not exist. So this taxation, if it could exist in Brazil, we don't have a GAR, we don't have the GAR, for sure we don't have a SAR, we don't have a specific rule for avoiding these illusions. So we have this attempt in the '01, was not admitted by the Congress. So what would be the sufficient elements that the excise question a structure that is questioning could be admitted by the administrative and judicial courts. So it has to be simulation that should be truthful. We were heading, just wrapping up in a scenario '09, '10, in Tijuca's case, of weird case, interesting, but by a procedural vicious, it was they find the wrong taxpayer, so the infraction document did not explain well and was cancelled. The one that had deferred the income and how did the money reached that individual. We have the O50 in the case Cosa, with no digressing in detail. So the what showed us allowed us to say that yes, there was a higher risk and possibility of understanding of a simulation. And now, what makes one confused is in 023 we have a sentence, which is this one of CPFL, that we don't have a simulation, and the appellate sentence admitted did not have a simulation. It was legitimate, it exists for many years, and even though it was not considered this structure based on the understanding that it was a abusive tax planning. So we must, that's why congresses like this one and the others we attended and the ones we have opportunity to talk, they are very important. This is because we must create this alignment and case law that is more clear, where again, not guiding that specific taxpayer, but the whole society to be guided. This is very important. I end thanking your attention. Thank you, Professor Ana Carolina. I recall that this text you mentioned of guard, when I was fresh student, I read it and it said that it will be miles length taxation in a parallel line with arm's length. So there was no justification for taxation. So the final remarks of Professor Ana takes us to the presentation of Professor Maista with the golden keys. Professor Maista will talk about the anti-abuse rules with anti-abuse rules in the domestic legislation. And one of the examples, in addition to the European law, is the indirect transfer of assets. So, Professor Maistro, you have the floor, please. Mu
you all. I will start my presentation. I will change it a bit because, in a way, the topic is the right topic, which fits very well into the previous debate and presentations, which is precisely the interaction between domestic rules, especially anti-abuse rules, or rules which may have a function of an anti-abuse rule, because you did draw a distinction between your simulation and GAR, saying you don't have GAR, but you have simulation, although maybe the purpose is sometimes similar. And indeed, my presentation has to do with the difficulties of interacting domestic rules, especially anti-abuse rules, the general anti-abuse rules or special anti-abuse rules, with treaties, especially now that for countries which have signed the multilateral convention have also to drill and to address with the PPT. But what I will do, I will perhaps devote part of my presentation to some comments relating to the previous presentations, because they are good examples of the way issues do arise domestically and how other countries may have dealt with these issues. And I will start with the last, let's say, presentation. The last presentation on indirect holdings. Well, of course, it's difficult for me to take a position relating to a specific, let's say, country, because I'm not familiar with how the domestic rules operate, but the issue is familiar to me because we do have similar issues relating to indirect holdings, but we do have a GAR. So we do have a general anti-abuse rule, which is in Italy, which is very similar to the PPT, so one of the main purposes, but we do also have a rule which fits into domestic law, which is a simulation or sham, which is, however, included in our tax rules. So based on factual circumstances, you can disregard entities, and indeed our tax authorities have applied such rule and try to look through foreign entities which had only one asset represented by shares in an Italian resident company. Just to say how different rules may be, you made a reference to Nexus. We know that especially most recently, the issue of indirect holdings has attracted policy makers and interest of academics. I think there is also a quite recent study of the IMF on this aspect about the policy and the nexus. And the nexus, as you know, is one of the topics of the Cape Town Congress, so that is one more reason to come and to go to Cape Town. And just to make an example how legislations may be creative, in many countries until January 1st of 2024, a foreign entity could be regarded, a foreign incorporated entity could be regarded as an Italian tax resident simply because the main asset was based in Italy. So when you mentioned about how can one justify the nexus, I think that one way could be, rightly or wrongly, to say if the sole asset is a domestic situs assets, then you attract the tax residence even, or you may attract the tax on the gain, something which at present is accepted the treaty level solely for companies which have substantial immovable property interests. So I have sympathy and for the special anti-abuse rules when they are there, but I don't think that a GAR or a simulation could apply under these circumstances. At least that would be my position in this particular situation. We do have special rules, special anti-abuse rules related to indirect holdings, but solely for interest in immovable property. But it might be a development in the future. So that goes for the first presentation, actually the latest presentation. I also had comments before I move to the PPT to the other two presentations. The one on goodwill. We did have the same provision in Italy. I'm referring to my country simply because it's one of the few, probably in Europe, which for many years had a similar rule, a rule whereby you set up a special purpose vehicle, you buy shares in a company, then you merge, and then after the merger you can depreciate what we call the merger deficit, namely the difference between the purchase price and the net accounting, the book value of the underlying assets, and then you depreciate that. And we had indeed, for many, many years, case law, sometimes in favor of a taxpayer, sometimes in favor of the tax authority, until the time rules were enacted. But one of the main reasons for which that provision is no longer there is because of the rationale of that provision. So I don't know whether you went through that sort of reasoning, which I believe is important. Namely, why do you have the depreciation of the goodwill? Is not a special benefit, it's probably a symmetry with the taxation of the gain. So you tax the gain on the sale of the shares, and you are taxing goodwill, which is generated by, which is already taxable on the company. So in order to avoid economic double taxation, you permit the buyer to depreciate the goodwill. So the way one will need to look at those structures, at least in some countries, would be to look at the object and purpose of the provision as well, so that if you have taxation on the gain, you are entitled to have depreciation on the goodwill in order to avoid double taxation. That is at least the way we dealt with it. Obviously, when the buyer is a foreign entity, then the problem is how you can have a consistency between the depreciation when you set up the special purpose vehicle and then you have a merger, and the non-taxation of the gain because you have a treaty protection, because the gain on the sale of the shares of the company would then ultimately be exempted from tax because of the treaty. If a treaty were to follow the model convention, the OECD model convention, granting exclusive right to tax solely to the country of residence. And that situation seems to me very similar to the Alta Energy case, the Canadian case, where one looks at the object and purpose of the specific provision of the treaty, which is to grant exemption in the source state. So that situation where a non-resident sets up a special purpose vehicle and does buy and merge when a target company and take the benefit of the depreciation, that would be something which would not be inconsistent with a subsequent exemption of the gain in the source state. So that is something which, again, is familiar to me, but we did pay attention to the symmetry between, the frustration of the purpose of a rule, because the depreciation of a goodwill was not regarded as a sort of, let's say, special incentive, but as a sort of symmetry in the context of corporate tax rule. And then I think just one also comment on the CFC rules and the compatibility with treaties. In Europe, we don't have this problem any longer, because not only because of the way we may interpret the provisions in the treaty, taking the benefit of a commentary, but because we have EU rules which require member states to have CFC rules, and EU rules override treaty rules, so we no longer have an issue of interpretation of bilateral treaties, which I found when court decisions, which we have in some European countries on compatibility of CFC rules, the ones decisions which were delivered, at least in my country, in favor of the application of CFC rules in the presence of treaties, were, in my view, rather weak, because they relied without a strong reasoning on the commentary to the OECD model, and the commentary was just a commentary, so relevant for the interpretation of treaties, but the language of treaties should prevail, and the position, as you mentioned, the position of the commentary on the interaction with CFC rules was most of the time made in a version of the commentary which was delivered after the conclusion of the treaty, whose rules were to be discussed. Well, this being said, I will now address some of the points which are included in my presentation, and I realize that I am making reference to the principal purpose test in a country where, number one, if I understand, you don't have a GAR, and number two, you have not signed the multilateral instrument, although I understand that you have in bilateral treaties included PPT after 2017. I think that I read Professor Schweri's article on the impact of the BEPS multilateral instruments for countries which have not actually signed the multilateral instruments. So I was surprised to see that the PPT is in your treaties, and I listened with attention the comment which was made yesterday after the first session. I'm sorry that I don't recall the name of the presenter, about your domestic law issue relating to a PPT in the treaty and your, let's say, domestic rules which have on abuse or on tax evasion or tax avoidance are in between ordinary law and constitutional law. So the point was made yesterday, I think, that a PPT could not override, could not be applicable and could not override your domestic rules, which require a certain specific rules in order to apply anti-avoidance rules. I simply, of course, I don't interfere. I'm not in the position to say much about your domestic rules. Maybe the only point which came to my attention was the Vienna Convention, Article 27, which, if I'm correct, basically says that treaty obligation cannot be, let's say, avoided just by referring to domestic law constraints. Although here, most of the time, there will be no harm to the other contracting state because if you don't apply the PPT, then you would be basically create a problem only to your domestic, most of the time to your domestic, let's say, taxing rights. Now, with being said, I want to indeed address a few points, and I will stay with this slide, which is because I like more to have a sort of conversation rather than going through very technical slides. And so the whole point I want to make is the interaction between the PPT and the domestic general anti-abuse rule, the PPT and a domestic special anti-abuse rule, and then also the PPT and a special treaty anti-abuse rule, more in the context of the relationship with between treaty and domestic provision. I think the main point basically that I want to highlight are the following. The first one has to do with the general anti-abuse rules that in the country are subject to special procedural requirements. In many countries, in order to apply a domestic anti-abuse rule, you need to follow certain procedures which are in the interest of the taxpayer. So taxpayer rights are especially protected, and there are certain administrative rules. And when we do have a PPT, as we do have because of a multilateral instrument or because of new treaties which are concluded, then the issue does arise whether the same procedural rules which are granted to taxpayers under the domestic anti-abuse rules should be granted to taxpayers also for the PPT, being the PPT an anti-abuse rule, and therefore there should be a symmetry in the protection of taxpayer rights. That is something which the OECD commentary to Article 29 makes reference to special domestic procedural rules, but it doesn't obviously say that there is an obligation to apply the same rules protecting the taxpayers, because it is probably regarded to be more a domestic issue. So that is the first aspect of interaction between PPT and domestic rules in the contracting state. The second aspect, which I regard to be important, has to do with the possibility for a taxpayer to lift the application of a special anti-abuse rule. In many countries, special anti-abuse rules which are denying the benefit of a tax provision, permit the taxpayer to provide contrary evidence to the effect that the transaction was not abusive. I can give you an example. The example is the holding period. In many countries, we do have that also in the treaty context. In many countries, you are entitled to, for instance, the participation exemption on dividends or capital gains only to the extent that you have held the shares of a company, so the asset which is generating the income for a period of, say, at least 1 year. And that is regarded as an anti-abuse rule in order to avoid what we call a sort of dividend washing technique. There are situations in which, in domestic rules which have the same, let's say, wording, the taxpayer is entitled to lift the application of such anti-abuse rule because we don't accept the idea of an absolute or conclusive presumption. So if a taxpayer may document that the failure to meet the holding period was not due to abusive reasons, then the taxpayer has the right to lift the application of the special anti-abuse rule. So the situation could be the one where the taxpayer is purchasing the shares, it doesn't hold the shares for 1 year for reasons which are not due to an abusive purpose. If that happens under domestic special anti-abuse rule, then the issue does arise if in a treaty, special anti-abuse rule, when one contracting state is applying the special anti-abuse rule, should grant the same right to the taxpayer to lift the application of a special anti-abuse rule. There is a reference in the OECD model convention, the commentary, to the alternate possibility for contracting state to provide or not to apply the special anti-abuse rules, but in many countries this should not be an option for the states, for the contracting states, but it should be more, let's say, the right to be granted to the taxpayer in order to align the rights of the taxpayer under domestic special or general anti-abuse rule, to grant those rights also to the same rules when such rules are treaty rules. So we have a number of issues which are related to the rights of taxpayer in the context of treaty rules, and obviously treaty rules relating to anti-abuse, they cannot go into the peculiarities of domestic law, so each domestic law should adjust either through special domestic provisions or through administrative provisions. The third one aspect, which again is to be looked at in parallel between the domestic anti-abuse rules and the treaty anti-abuse rules, is the following: is when an anti-abuse rule, say principal purpose test under the treaty, makes it such or ends up with a denial of the treaty benefit, so assume that the dividend relief in the source state, so for instance a reduced withholding tax is denied under the treaty because of the application of a PPT, then there are two possible results. The first result is that you apply domestic law, so the domestic withholding tax, the one which would have applied in the absence of the treaty benefit, or following the domestic anti-abuse rules, you grant the taxpayer the same regime that would have applied in the absence of the abusive conduct, which might lead to the application of a treaty with another country. So I give you the following example. It is a situation which come to my mind because of a recent, the facts are similar to a recent Canadian case, which is described also in my presentation, ASCII Energy Inc., which was decided on the basis of beneficial ownership. But basically, in that case, which is quite interesting, in that case, a taxpayer transfers shares from one company to another company in order to move from a treaty regime which made the taxpayer eligible for a 15% reduced withholding tax rate, and the abusive conduct led the taxpayer to obtain 5% reduced tax rate. And the result was the transaction is abusive. And so here you may have two different ways to deal with it. The first one is to say it is abusive and therefore I apply domestic law, 30%. Or the second is I have to apply the same regime that would have applied in the absence of the abusive transaction, which would be 15%. So the same regime that would have determined the application of the treaty. That possibility, namely that you don't deny 100% the treaty benefit, but you apply the alternative regime, you may find that in many domestic anti-abuse rules. So when you do apply the PPT under the treaty, then the position should be that the taxpayer should be entitled to have the same possibility to apply alternative, let's say, regime, which is granted under domestic anti-abuse provisions. Otherwise, the PPT would create a detrimental effect and create distortion in the relationship between the PPT and domestic provisions. So these are three, let's say, examples of issues which do arise in the coordination between PPT being a treaty anti-abuse rule and domestic system, particularly domestic anti-abuse rule, general anti-abuse rule, or domestic special anti-abuse rules. And with that, I think I'll stop here. Thank you very much.
Muito obrigado, professor Maisto.
Thank you very much, Professor Maisto. And I think that with this, we can close this session. And now I pass the floor to our chair. I would like to thank for the coordinators of this Congress, all professors for the invitation, and also to my colleague panelists for their company and also partnership here. And please continue to send your questions through the QR code that you see on the screen. On the last panel of the day, we will discuss all your questions. We have already received a couple of questions, and we're going just to keep them until the end of the day. So, please, Mr. Gustavo, you can just close this panel. Thank you, Leonardo. As was said before, we had very brilliant talks during this panel. I congratulate all the guest speakers here, and also I would like to congratulate the planners of this event that has been of high excellence. Once again, congratulations to all the planners, and with this, we close the first panel of the day. Thank you.